Good morning, good afternoon, good evening. I don't know, different time zones people might have joined. So, with due respects, I would jump into the slide. Um, I would like to really kind of set a context as well as how I'm going to really. I'm not going to follow the slide. I'm going to. I would like the slides to follow me, and let me jump into the presentation. And the two things I want to, uh, I mean, uh, be clear. Like hope my voice is clear to all of you, and my presentation is also visible to you. One of you or any of you kindly send
Yes,
a
sir.
thumbs
It
up.
is visible and
So
your audio is clear.
thank you, and
Sir, your body is clear, sir.
thank you very much. So this material which I've coined in the context of that what we are planning to do today in the webinar is to understand uh, a better understanding of the India's data privacy DPDP Act. This is I put my disclaimer there. I'm not going to read it. It's kind of a session where I would like to share the knowledge which I've understood with this larger forum. Thanks a lot for really allocating your valuable time to listen to me. And how I'm going to really carry out the session will be coming in the coming slides. Okay. Uh, so before I jump into the actual material, I thought I'll just present a scenario to the audience and probably seek your quick response. You can just respond in chat, yes or no. The scenario is when an individual X defaults on their monthly loan repayment to bank Y, the bank may process X personal data to ascertain their financial information, assets, and liabilities. And now the DPDP Act clause is very clearly mentioning the right to correct and erase the individual. That is, we call the individual whose data is getting processed in the context of DPDP Act. There is a terminology called data principle. So, as for right to correction and erasure, by the data principle of the DPDP Act, Mr. X demands erasure of personal data. He's a defaulter. Remember, can it be or should it be erased by the bank? Quoting DPDP. Kindly send your. I mean, there is no right or wrong. So please, yeah, go ahead, go ahead. I think I've already started getting. No, okay, no, okay, yeah, keep sending. We may find the answer not immediately. Of course, it is a kind of a setting a context in which we are going to discuss various things today. So that is the reason I brought out this scenario. Let us jump into the next one. So in the today's webinar, I'm going to really not just start with the DPDP Act straight away. I don't want to be really boring the audience with all the definitions or this is the explanation. It is all self-explanatory. Anybody goes through the document will be able to understand better. Only thing still, I have provisioned the second topic, subtopic on DPDP Act finer details. But before that, in the context of digital protection, I mean, we rather call it Digital Personal Data Protection Act 2023. Of course, with the due respects, I've used Indian flag with the due respects to our mother nation and starting this. So, hypothetical case study we'll do first, so that we understand, the context in which we all operate practically, and that has to really throw not just the information on or introspection on or the perspective on DPDP alone, but also what is there on the ground and how we are going to really match them. And definitely, the notification when it comes, it will have more finer details. But for as on date, whatever is available, I will walk through that in the section 2. The first section will go to a hypothetical case study analysis, and then third and fourth we'll look into what are the different implementation challenges one may face, and also we will see sector or industry-wise implementation challenges, or what needs to be really taken care in the context of DPDP Act. And also we will do a small analysis on cost implications. This is not accurate. kindly, this is just treated as an hypothetical cost analysis, cost implication analysis. For the sake of the entire exercise is for the sake of not just getting the knowledge, but also getting a finer details. And my intention of this particular, deck or the speech is not just I want to share the data, but also details, but also I want those details to remain in your minds for as long as possible, so that you go and dig further and then get a better understanding, so that you add value to whichever setup you belong to. And you won't believe, I am sorry to say that I got 120 slides. I know I cannot go through every of them. So I put around 70 in the appendix section, where I leave it to your self-study, which I will share this particular, this is a PDF I created. I will share it with the organizers. They will share with you. Okay. So we'll jump into next one. So data protection and the personal data protection more precisely, uh, um, not protecting that can lead to what are the possibilities which we are already facing, right? How many of us have got are getting a lot of calls in the mobile from somebody whom we have not shared the data at all. So personal data misuse, unsolicited emails, calls, and fraudulent credit card charges. And there is nobody shoulders responsibility. ES called, what can we do, sir? This is from the database, that kind of thing. And DPDP Act implications, companies now held accountable to prevent such scenarios. So the intention is, Government of India, this is not the first time in the world this is happening. Many countries have done. We are not going to go to the details of other countries, but definitely in the context of DPDP, this is a good step forward, because IT Act India is already there. And basically, if you really see, as long as the information technology, information security aspects are completely protected and taken care by the industry or the environment or the enterprise, it should be taken care. But still, there is a granular level of protection required in the for the personal data. That is the reason it is in place. So, sorry. So we are jumping into the first topic, hypothetical case study analysis. Okay. So where we have taken up a small company called Smart Shop. The presentation explores the challenges faced by an Indian e-commerce platform, Smart Shop, in complying with the DPDP Act. You may ask me a question. You have not told me what is DPDP Act, and we are getting into a case study. Yes, we are getting into a case study, I know, but this is to throw some kind of a context and setting the context and getting the understanding of what we are going to talk in the context of DPDP Act subsequently. So we will delve into specific use case, practical issues, and it is not. It is easy to really read the act and then understand it, but how to really implement, how to really bring it to the practicalities matter a lot. So in that context, I thought this may be a good starting point. So let me get into. You may find in my presentation some kind of, for the purpose of clarity and also bringing in attention, I kind of added certain pictures. So whatever I'm discussing here, which I am highlighting, matters. This picture is just to set the context. That's all. Okay. So in the context of DPDP, it is important. The DPDP specifics, we will go to the details little later. Consent from an individual, the consent is very important for using their data for the purpose of the processing. Okay, but fundamentally, there is an individual who shares, he or she shares the data, personal data, maybe mobile number, etc., mobile number, name, address, etc., etc. So, okay, let us get into the consent management challenge. So far, all along this particular smart shop has been doing business, so it has already collected. But the DPDP Act mandates consent is important. So it is important for them to really bring it retrospective compliance for my millions of users. I'm not going to go through the the finer wordings, etc. I've kind of highlighted the DPDP Act mandates explicit, blah blah blah. All those things I'm not doing. So that is a practical issue. Okay. So the solution also likely solution, not necessarily this is the only solution. So there is an issue when you really handle consent management in the context of DPDP for an enterprise, but you have solutions available. Definitely, that is, if you really say every case, there is a challenge, there is an issue, the solution and cost impact. And the cost impact is taken very hypothetically. It may vary very larger extent between enterprise to enterprise. Okay, just for an understanding of an estimate, I put this cost. So please understand that part. So the message from here is concern management. Yes, one can say, putting in the lighter sense, let the world live happily. Okay, how the world is going to live happily matters a lot. So similarly, I'm not undermining DPDP Act. I'm not talking against it, or I'm not saying it is a difficult task or impossible. But there is a challenge: consent management. We have seen in this case of this hypothetical, scenario. Number one. Number two, data localization. So which means we tend to understand. Hey, there is a consent management clause in the DPDP Act. That is the message I want to give all of the participants here. So that when we really go to the actual act, you please connect these two and get a better understanding so that it registers. Okay. Second, data localization. Challenge is payment related information. Maybe the data, the DPDP, may mandate you got to store it locally, but there will be, this company may be operating globally, so it has to really migrate a lot of data back and forth, maybe global to local, local to global, depending on the use case. So again, cloud solutions may be helpful, provided with that has got cloud solutions is supposed to be having the global and local flexibilities. So that is one of the possible solutions. So data localization is another thing. Then it is not necessary that the smart shop will be doing all their processing by themselves. So imagine you have provided your data to the smart shop, okay, and they process that in with the third parties, multiple. Somebody may be doing payment details, somebody may be providing something else, some other service where they have to share the data. So in the context of DPDP Act, there are different definite terminologies for all these parties. The individual, as I told you a while ago, they are data principal, and the person or the body which decides what kind of data to be acquired and why it is to be acquired, and what they need to do and why they need it, and all these things. They used a very beautiful name or nomenclature in the act called fiduciary. I mean, I was kind of thinking into, like, should I pronounce it as fiduciary or fiduciary? Then I kind of did a Google research and other things. I pronounce it fiduciary, but we'll be seeing this terminology shortly. Please get used to those terminologies slowly. Okay. So challenge is logistic partners handling delivery addresses. For example, address is definitely personally identifiable information, right? So do not have robust. Your third party may not have the robust protection policies. So it is important for you to have a regular non-disclosure contracts, vendor contracts, as well as vendor assessments. There are so many things required, but it's not in a single day it can be implemented, but it will take time. We will also be seeing the challenges in implementing shortly. Okay. Then data minimization and purpose limitation. This is also emphasized by the DPDP Act. That is, get only those data which is required for that particular purpose. For example, I need your phone number. Okay. At the time of asking your consent, I just send a mobile application to you and say that, please provide me access to your contact list. Huh? What sense it makes? Okay. Why should I give consent to accessing my contact list? Okay. You need my phone number to deal with me. Okay. But we'll park this question and we'll come back to that later. So what data you need? for the purpose, need, purpose must be very, very clear. Okay. So date of birth for consumer profiling, which is not directly linked to its core services. You may ask date of birth of individual. Okay. Why? Then you will be able to segment the customers, right? Young customers, we provide this kind of products, etc., etc., right? So, I mean, the DPDP Act mandates all those things, like how you have to control, ask what is needed and what, and with the purpose and for the period it is needed. So the problem is I've already been doing that, but I've been collecting enormous data. So now I have to really minimize it. I have to trim it. So that itself a challenge for Smart Shop, right? So data minimization and purpose limitation. Please, all my whatever I'm saying should not sound to you kind of hey, this guy is talking, pessimistic on the DPP. No, no. These are all challenges, practical issues. So slowly we try to understand. We kind of understood so far the DPDP Act that we are going to see probably in the next section talks about third party vendor management, data localization, data consent management, and minimization and purpose limitation. That orientation I'm trying to bring through this particular hypothetical case. Then, okay, with all the controls and everything in place, breaches can happen. That is why reporting, incident response teams are there across board. I mean, it requires what in case it has happened, what you need to do. DPDP mentions about it. So it requires timely breach notifications to the Data Protection Board. That is another terminology. Please remember, we'll be talking on that. There is about 23 pages of document, DPDP Act actually. Okay, 2023. So and invest in advanced threat reduction tools like, I mean, just a few tools I've given them as example. Intention is, it is not, it is your act, you need to act very swiftly. You got to go very quickly because something has happened, because the the penalty, the for a breach, it is enormous, and when it consumes time, it is really going to cost you more. Okay, so breach reporting is very important. Okay, so then users rights enablement. I mean, you have to enable the users to access, correct, and delete their data. I mean, and streamline rights management, their rights. So far we put a disclaimer and kind of say that yes, agree and go ahead. There are rights again being talked by the DPDP Act, so which needs to be addressed by this hypothetical company. So you can imagine, when the act is in place, there are a lot of things an enterprise needs to be really doing. That is what I'm kind of trying to bring the orientation. Okay, and of course, in addition to that, enterprises have got certain way of functioning and internal culture. I mean, maybe orienting towards information security. It may not be specific to the data protection of digital data or data protection of individuals or personal data protection. So the new process the enterprise may employ to do that, and naturally any change will bring in its own challenge. So and awareness may not be there. They may think what we are doing is the right thing, but then as an enterprise, it's a Smart Shop has to bring those knowledge, and definitely workshops and trainings help. So so this let me pass here. I'm sure I will be able to cover all my 4 sections because I go with certain extempo talk along with the slides which help me. So hope that has set some kind of a practical context to understand the DPDP. Please share your point. I mean, yes or no, or are you happy with? I mean, in the sense, what is the best source to learn about RBI guidelines on security recommended by fintechs? Okay, that we'll talk about that later in text. Okay, I saw your question. So, any questions up till this point before I take on? I mean, next slide is purposeful blank, and before we get into actual, the main topic only comes now. So far, it's only a trailer. Gentlemen, please. Any questions or anything you would like to kind of express.
Sir, like any specific challenge till now, if you can say based on your experience for 2 3 minutes, we'll get some knowledge on that.
We will move to that shortly because
Okay,
I
sure.
got the. I mean, I have not gone to the main thing yet. Yet I'm
Oh,
setting the
fine, fine.
context
No
only
problem.
so far.
Okay, thank you.
Hari, this
Thank
is
you for
Mani here.
asking.
Just one question. Apparently, looking at the amount of data breaches that are happening, it is leaving an impression that practically it may not be feasible to stop this 100%, okay, from happening, particularly the B2C companies in the current age. Maybe you may want to reflect your thoughts on that. Thank you, Hari.
Sure. Let me note down these questions so that I don't forget. 1 minute. Kavita, can you note down those two questions, please, so that I can focus on this deck and come back to it.
Sure, sir.
Okay, thank you. Yeah. So now we get into the action. I mean, answering to your questions, Mohanji. Now, let us not be pessimistic. Actually, there are possibilities. Companies are doing information security very well, and they are every day it is improving. And similarly, personal data protection is very important. And that change, when it happens initially, it may sound difficult, but over a period of time that will happen. As on date, if you ask me, yes, you are right. We may think that, hey, how we are going to really cross this sea, but we are going to cross it. And if you ask me, somebody asked about the use cases specifically. Honestly, very difficult to bring out. I don't know how many companies are really getting into. There are, when you come to ISO or any such framework, ISO 27001 is one framework, and ISO 27701 is another framework. Not many companies are jumping into that 27701, but there are companies who are actually doing these two together so that they understand their gaps and try to fulfill those things. So we'll go to the very act, because for the clarity, I put a few slides to understand the act. It was enacted in 2023. It governs data collection, processing, and storage, which means data processing, data usage, and data storage. So all the three stages of the data, the personal data, once you take it from an individual, it is important. So a lot of questions will come. Like we started during the beginning of the discussion, somebody defaults and say that forget my data. Uh, the DPDP is very clearly giving all those scenarios. In fact, the very DPDP Act itself, around 13 scenarios, 13 or 14 scenarios are very clearly discussed. So it's a beautifully documented one, actually, very beautifully documented one. So, and it empowers data principles. Here, the data principles is the individual whose data, is to be protected. So, individual rights it enhances, and business has also got obligations. So, business, on one hand, business obligations have been enhanced, and individual rights have been enhanced, and rules and regulations are put into place, and the notification with the appropriate framework and other things will come, and we'll come to know about more finer details of the framework, other things that we need to follow once the notification comes out. To the best of my knowledge, until date, notification has not come. Okay. So the importance of DPDP Act, it has, as we saw in the last slide, empowering the individuals. I mean, we saw the what is DPDP Act, and we look into the importance. Gives people control over their personal data. Okay, and business is accountable for that, and there should be a safer digital landscape. This is the intention of because over a period of time, as we saw in the very first slide, what are the possibilities and other things. Accountability is going off. Supposing now, I don't know, maybe down the line, once you share the data to somebody else, and if it has gone somewhere else and you started getting issues, that somebody else who you have shared the data is responsible. Fiduciary, we call it. Okay, so those things will be terminal. Next few slides will only stick to the act. Okay, and then we'll go to the challenges. Key aims of DPDP Act to protect personal data and empower individuals. re-emphasizing everything. You may look into, you might have seen, and facilitate. It is not just hold the business accountable for it. Also, the act facilitates, to help them streamlining the requirements. Okay, and it has to be in harmony with the international frameworks like GDPR and other frameworks we have got. So definitely India also leading on that. And if you really observe very closely into this document of the DPDP, it will refer everywhere she, and very clearly that is gender neutral. She means he, she, and all third gender. That is very clearly everywhere in the document. You will refer data principle or anybody they want to refer an individual, they refer it with she. It's a very meticulously planned document, I would say. Okay. So key definitions, please. There are many key definitions in the Act, but I picked up only the 5 definitions. You may see 4 on top and one at the bottom. Data principle is the individual to whom personal data relates. And if you ask me what is personal data, it can be anything, right? It can be anything which can identify an individual, right? I mean, that includes not just major, but also minors and persons with disabilities, very clearly, narrated in the Act. Actually. Then fiduciary, we call it, is the entity that determines the purpose and means of personal data processing. In the case, a hypothetical case that we have seen, the smart shop is the fiduciary, actually. And the data processor is the processor who processes actual data on behalf of the fiduciary. For example, somebody deals with delivering the goods in the smart shop context. The delivery third party is the data processor, and anything the data processor makes a mistake, fiduciary is held responsible. Okay, and then personal data breach is defined as unauthorized access, use, or loss of personal data that compromises confidentiality of the data principle. And when it comes to fiduciary, it is the Act is mentioning about 2 kind of fiduciaries. One is the simple data fiduciary, the other one is significant data fiduciary, and where they have given certain descriptions. But by and large, the brief summary is an enterprise notified by the government based on factors like how much of data they're handling, volume, and how sensitive is the data and the impact of the same. So when this particular definition, when you see, one may question a couple of things. Hey, I've got so much of my personal data in Facebook. One, I've got so much of my personal data by the whole being held by the government. 2, okay, these questions will come to your mind, right? Naturally, it came to my mind. I hope you also get it. Maybe we will see the answers in a couple of slides later. Okay. So these are the definitions, and what are the different business obligations under DPDP Act? Minimization. Do you remember this term I used in one of my slides for the hypothetical case? Collect only what's necessary for services. The beauty is I would have already collected millions of data with more information so far, and going forward I have to minimize it. There is a Herculean task, actually. That's what we highlighted in the smart shop context. Okay. And purpose, the limitation. Use only data for intended purpose. Means I may collect your phone number only to talk to you and deliver certain things. And once the job is over, that's it. Not that I go and tell somebody, hey, his phone number is this, and without your consent. I can't do that. Okay. And implement robust security practices. It is easier to say that, but very tough to do. We'll see that. And data retention and disposal. Securely delete data when no longer needed. So data acquiring the data, processing the data, using the data, and securing the data, and as well as retention and disposal of the data. The entire life cycle has got responsibility on the business, the fiduciary, not even the processor. Processor in turn is answerable to fiduciary, and fiduciary is in turn answerable to the principal as per the Act. And the Act very clearly, very clearly in some of these wordings mentioning about children data. And I put kind of a summary here, but you may see the fine words in the Act actually. It is important. Anybody less than 18 years, 18 years very clearly mentioned in the Act, less than 18 years old, it is important to obtain parent or guardian or any appropriate person's consent. Number one, you can't say that I handle this child's data because it's child, I don't have any consent. No, it's not possible. And it is important every action the business is doing, holding the data, having the data is to protect the child's well-being. That's very, very important. As mentioned, I'm trying to highlight the DPDP Act, requirements. Okay, and you can't do as a business targeted ads for children. And monitoring their behavior or monitoring their behavior. If you target the advertisements, that is prohibited by the Act. Actually, so the children area is fairly taken care by the Act. So let's see how the industry is going to respond to it, how we are going to have an environment down the line in few years from now. Maybe a safer one than what we are really kind of facing now in terms of data leakage and other things. Okay. So individual also called the data principal rights under DPDP Act. An individual is having the right to access their data anytime they want, and they transfer the data to another organization, and if they want to be corrected or erased, you should provision that. So far you will be obtaining and storing, but you should also provision for them to really, through some kind of an interface, if it is a automated processing, them to really, for example, you keep receiving unsolicited emails, or which probably you would have subscribed in the past. There should be an option for unsubscribe, or something like that. Something like that for your personal data also should be there, implemented. And also you have the right to, individual has got the right to withdraw the consent. But again, the Act is really going to the details, and with finer information, very, very much available in the Act itself. And the use case that we saw, the first slide, a defaulter information, even if they want, because the law of the land supersedes the law, or the statutory requirements, or the business case, or the requirement there supersedes. In that case, the principal, or not the principal, sorry, the fiduciary has got the right to not to erase the data. I mean, the answer is, the first slide, we saw that, right? Can it be, or should it be erased by the bank quoting DP? No, it is very clearly mentioned as an example also in the Act. Okay, so not that people can take it for granted. I've got a DPDP Act protection. I can do anything. That's not possible. So, which means it is very, very carefully thought about. Okay. So, and what will be the impact on business by doing this? Will be, customer trust and overall trust of the end users will be there, and of course it requires you have to really have new data practices. You may have to invest on certain spent on that, and startups must build robust data management systems. And in fact, the Act has provisioned or provided certain cushions and exceptions for startups, and of course, obviously, government also. Slowly, we'll see that. So, not that everything is rigid also at the same time, and long-term benefits outweigh the costs of non-compliance. The penalties details will be seen shortly. So some of the illustrative scenarios I've given here, where the DPDP Act outlines specific scenarios where provisions may not exactly apply, please, as well as guidelines on consent, data retention, and legitimate processing of personal data. And these examples are explained as scenarios in the DPDP Act. If you go to the DPDP Act, actually, you will see scenarios with X, Y, Z, personas. But I kind of put them as a snapshot here as a summary. If an individual publicly shares their personal data on social media, the DPDP Act does not apply. And it is possible for to obtain the consent through video or any other means. and the bank has to provide notice on a personal data being processed. I don't want to be reading every line. So on the existing data, it is important to get the consent again. I mean, if you have not got it in a retrospective manner. And it is important to mention very specifically the purpose of the consent. Okay, a telemedicine app can only access users' contact list if it is necessary for the service required. Okay, and invalid consent conditions. This is a very beautiful point given by the DPDPA. Somebody has consented. Okay, I've told you an example where in my mobile app, I got my fiduciary got a consent from me for my mobile number, accessing my mobile number and my contact list. I said yes. Okay. I said yes. And they started asking my contact list. And they started doing, some of their processors or some of their third parties started doing something which is not expected to be done. And I want to file a complaint with the appropriate data protection authorities. Now, the fiduciary comes and says, "Hey, you've already given me consent. Eh? So why should you lodge?" No, the DPDP Act says, "Hey, you've taken the consent. While taking the consent, you should have the business case for that purpose. But things are happening in a different manner, and every right the data principal has got to go and file the complaint." So there is a lot of protection. Even by mistake, you have given that consent is not required, but you're given. It is mandated or you're given. And it is not used for the purpose of it is supposed to be used. And you wanted to file a complaint. And the principal, the fiduciary comes and says, "No, you cannot do that." No, the DPDP Act very clearly says you can't waive the complaint. They will go and do it. So imagine the protection level, okay? And individual can withdraw consent, but businesses may continue processing data for specific purposes like order fulfillment, or in the case that we have seen now about bank case. Okay, and government data processing. Government can process personal data to determine. So many programs government has got that. Government has got all. They're exempted. And retention for legal complaint, businesses may retain data for the time period required by law even after. So please look into this scenario as given by the DPDP Act. I kind of put it in yeah. So, and next few slides, what I'm going to do, I'm not going to read them and all. There are, if you really go to the DPDP Act, it has got a totally nine chapters. Okay. And each first chapter talks preliminary definitions, etc. Second chapter talks about the fiduciary's obligations and whose fiduciary? The business, right? And chapter 3 talks about rights and duties of the data principal. Chapter 4 about specific provisions like cross-border data processing exemptions, processing as well as exemptions. Exemptions, I told you, like there are certain cases exempted, which we'll see in one slide shortly. And there is chapter 5 onwards, it talks about something called Data Protection Board of India. I think, I'm not sure whether it is really constituted yet. It may be constituted. I don't have the clarity on that, but definitely that is the authority. Okay. And there are so many things in the DPDP Act. They have given how the DP Board of India has to function, how they have to appoint their chief, and how they have to work on, so many things are given very detailed. So you can think of the 360 degree, because the very purpose of this webinar is giving an outlook on all these things. So that is the reason I am kind of revolving around all these things. Okay, and what powers and functions the board has got, and how the appeal and alternate dispute resolution can happen are all covered in 5, 6, 7, and 8th chapter specifically talks on various penalties and other things. And 9th chapter talks, protection in good faith, power to call for information, power to amend schedule, and Government of India is empowered with all these, whatever they want to do. So kind of given, just want to throw, an understanding. Okay, it is all covered as 9 chapters as on date with the 23 sheets there. So I kind of try to look into the. I'm not a legal person, nor this is a legal, implication. So kind of try to give it in 45 minutes, 1 hour, whatever I have kind of understood. So there are clear exemptions under the DPDP Act. MSMEs and startups, all obligations apply, but startups may be exempted for certain provisions. Very clearly given there. So imagine, because it is very difficult for the startups to operate, with all these challenges. I think probably, Mohan, I'm answering part of your question. So, IT is processing foreign data, only need to implement reasonable security for foreign residents' data. So these are also very clearly spoken in the Act. And central government can notify certain categories for exemptions from DPDP Act, and they are empowered to state government and central government are empowered to use the personal data in whichever fashion in the interest of public they can use it. So please be aware of it. Not that simply blindly can people challenge on the as per and based on the Act. Okay. So, this slide is throwing what are the different penalties possible. The penalties go up to 250 crores of Indian currency. I am not going to really go through each and every sentence, and because post this presentation, I'll be sharing this deck PDF with Kavita ji and Subhu ji, who will be sharing probably with the participants. That is left to them. So you can go through that, and this data is available everywhere. Okay. So, and we kind of mentioned the significant fiduciaries a few slides back, right? So data, for the significant data fiduciaries which have been declared by the government of India, yes, this enterprise is significant. It is important for them to have a data protection officer mandate, and they have to do an independent auditing, and also regular auditings have to be conducted, and there are impact assessments to be performed. So these are the things, especially for significant, significant. For your recollection, sometime back we saw an enterprise notified by the government based on factors like data volume, sensitivity, and impact. Okay, so this is why I would like to call out specifically on this in this particular slide. Okay, now the role of DPO also is specifically mentioned in the Act. They have to oversee the compliance and give the strategic guidance and liaison with the DPBA. You know what is DPBA, right? Data Protection Board of India, right? So that is the role of. So appointing a dedicated DPO is crucial for companies handling large ones. So slowly, it is multiple facilitation, I would call it. There is an Act, there is likely to be a framework, and there are some guidelines, and there are some norms fixed, and certain things have to be really taken care, and that will be controlled and monitored. So that kind of a framework is slowly evolving and making that as a kind of law of the land. So I think slowly things should be implemented. So purposefully I've left a blank here before jumping into challenges. Let me maybe since we started a few minutes late, maybe I'm left with 7 minutes as per the time given, but I may continue 5 or 7 more minutes, please. Bear with me, because 29 slides I've covered so far. I would like to take another 21 with some specific data. We saw an hypothetical case, and we kind of, studied the rule book, and now we go to the, challenges. The DPDP Act requires significant cultural, operational transformations across industries, posing complex practical challenges. That is a fact. Maybe that may sound bitter, but that is a fact. Okay, so let's see industry specific challenges as example only, not that this is a complete list. Healthcare, protecting sensitive health data and ensuring patient rights while enabling interoperability, because healthcare cannot operate in silos. Like they have to really operate with a lot of dependency on third parties, government, and so many things. And so healthcare very important. In healthcare, when the personally identifiable information or the personal data is matched with or mapped with maybe particular type of data of an individual, that is very, very alarming. Okay. So BFSI, banking, finance sectors, balancing fraud detection needs with privacy requirements in financial transactions. And that is a big thing actually. Retail, managing customer data sets from loyalty programs while adhering to data minimization. And manufacturing, and the list goes on. We'll be seeing specifically certain things in shortly. And of course, consent management, you need to implement. It is not just sector wise, but also to implement, which we have seen in the hypothetical case, systems to obtain, manage, and reward consent. Probably you have to re-engineer the system you are already working with, or you have to really give it to a third party and then integrate that. So many things are there, and it is important for you to provide a user interview. There's a technology upgrade, technology changes challenges available, and many of the tasks you may give it to automated systems that we have gone through during the hypothetical use case. So the challenges are there practically. We have to acknowledge, identify, and look for actions possible. Okay, across industries, a quick look. So what are the considerations across industries that we can have a look? Okay, what happens is when data is actually looked into, data is becoming, even private data or personal data is a data only. So to handle data, there are a lot of frameworks, lot of rules and regulations are already there. Coming to privacy data or personal data, there are some more specific things, like getting only minimum data, giving a consent, and only using the data for the purpose of it is to be used, etc. So when you come to regulatory compliance, BFSI, as long as it adheres to all these things, RBI, SEBI, RIDI, and UIDI consult guidelines, etc., it more or less actually fulfills. And the question comes, all the fraud activities and so many things. Once these rules are violated, the problem actually comes, right? And consumer obtain informed consent for data collection and usage. So what we are going to talk in next few slides is key privacy considerations these industries have to really take into account. That is what we are going to talk about. Data protection, implement encryption, identity management, and audits, which actually repeatedly getting repeated. Okay. And then health and privacy, patient confidentiality, electronic health records, securing them, and aligning privacy with research advancements, and sharing the data in a very secured manner becomes. All these things are the key privacy considerations if you take in a health industry to take into account. So I kind of tabulated things based on the industry, right? For banking industry, adhering to the regulatory compliance, customer consent, data protection by and large. Healthcare, the sharing data of critical data of electronic health records, and research for research purposes. You've got 50,000 people, health record for a research purpose. When you share, you cannot just like that share unless you get a consent from the individual, right? All these things will be in place when the DPDP Act is. And then manufacturing, customer data, ensure customer data is collected with consent. Of course, repeatedly I'm telling same. And supply chain management, especially here, it will be right. And IoT connected, we are advancing. IoTs play a major role there in the manufacturing sector, and IP, intellectual property protection. So it is the same stuff. By the end of the day, it is the same stuff. It is consent, minimization, localization, and right to forget, and protect and erase, etc. But for different industries, it has got a different formats. That's what I'm trying to highlight here to get some clarity. And if you take IT privacy one, enhance cyber security, competitive compliance with data privacy can provide a market edge It's a positive aspect. And prioritize data privacy to build a reputation for responsible data handling. And of course, with emerging of AI, ML, etc., a lot of data will be handled, and personal data is important. So data, I mean, I'm kind of not touching in these slides anonymization and pseudonymization. That's these two things are the talk of the town. Slowly, when the anonymized data, you cannot really reverse and check whether individual that identify that individual. Pseudonymized, it is not possible, but it is possible to reverse. It is not possible to I get the identity of the individual without certain things applied on it, but it is reversible. That, I mean, all those jargons, I don't want to bring it here. I want to put it very simple. And media and telecommunication target obtain user consent for personalized content ads. We saw in the case of children, you cannot even, based on behavior, you cannot even do advertisements, right? And for other targeted advertisement, it is important for you to get a consent. Like tomorrow, I don't want to name the company. You have seen a few advertisements of refrigerators. Sorry, few links of refrigerators, and that company cannot come and go give a targeted advertisement of a refrigerator to you unless you give a consent. Yes, I'm okay to look into the advertisements by the refrigerator companies. Unless you do that, they cannot do that going forward after the DPDP Act is in place. Data monetization, establish robust data sharing agreements to protect privacy. Consumer trust, demonstrate commitment to privacy to build loyalty, and incorporate privacy by design. That is a separate topic altogether. It's a very big one. But similarly, in the energy and utilities privacy, you have, I'm not going to go to the every details of it. I mean, it impacts every industry. It impacts energy. It impacts consumer products. It impacts real estate and GCCs. Okay, and GCCs again need to adhere with the GDPR as well. So all those things are in picture. Okay, so I kind of left. Left to your thought. Like, what are the? I mean, everywhere it is going to have an impact. This DPDP and how it is going to. Because I need to cover one more topic. So I'm maybe a bit fast. Let me pass here. Right? Let me not keep on be talking. If any concerns or any questions, so that I'll have to cover the breach response. I think that will come around 4, 5, 6 slides. Yeah, way forward. Yeah, oh my God, 7 slides. So up till this point, hope, I'm not sure. Let me get a quick feedback or questions, please. No questions? Is it overwhelming or it is too little? I don't know.
Maybe one question. I was expecting somebody else will go with the question. So if you look at so far, in Indian companies, particularly BFSI or even the government sector, many places over a period of time they have collected the PAN card, Aadhaar card of the public. People have also not bothered because there was no guidelines. They have given left, right, everywhere, those details. So we don't know which all places it has reached, who all have an access to that today. So do you think, it would be very challenging, right? Now, now that they're coming up with the DPDPA Act, we don't know. Personal data will be in the hands of many people now. How are they going to really enforce?
You're very, very correct. That is a challenge we are going to face. And if by any means, I'll ask you, after the DPDP Act is in place and your Aadhaar number is compromised, and you know pretty well you have given the Aadhaar number to fiduciary A, fiduciary B, and fiduciary C, and you got the right to go and complain in case that is being misused against the fiduciary. That is being provisioned for you. Now, depending on how the people are going to react, only can answer your question. Because if we are used to, okay, somebody is beating me, I know I'm used to get beating, no problem, I'll go on with my life. Then if such things happen, I mean, since there is a police force, there are criminals still operating. Unless the complaint comes to them, they will not be able to really act on that. Or if something surfaces, a very big scam or big issue, it is similar to what we have been doing in other, criminal or, even civil issues. This is another data protection area where definitely I'll tell you legal will be employed and the protection authorities will be employed. So it is not going to operate. I mean, it is not going to really operate the way in which we have been seeing already. It is going to be different going forward. Number one. Number two, answering your question on, okay, I'm an enterprise. I've collected the Aadhaar card. I know for this purpose, but I've already, I've shared with so and so, and this is impacting you. You come and complain me. Definitely, I'll tell you, there are cases, once it is proved, there will be penalties also. There are a lot of penalties involved. So, I cannot really answer your question just like that, but only time alone can give that answer. Now, but definitely, we have been traveling in a cold region, probably without a blanket. Now we are going to have the blanket going forward, and that blanket really is going to help me protecting me against the cold weather. Time has to answer. Maybe I may need additional blankets over a period of time, but it's a very good question. If you go to the act, yes, somewhere you take the whip, right, and start doing things so that people. I mean, all along we have been taking things into granted. Enterprise is taking things into granted. Individuals are taking into granted. But again, they put if and but there. Okay, if government is processing it, if government is doing something, well, no problem, they are exempted. So it is a kind of pros and cons are going to be there, and it is going to be challenged. It is going to be mandate, and in the coming time, all these things will be in place. And as I would like to give the analogy of the blanket only, the cold blanket. We are going to get a blanket. Okay. Now in the cold region, how you are going to protect yourself? Time has to answer. Maybe I've kind of given a detailed explanation without probably straightforward answer. I don't have the answer with me, but it's a big question. I'm kind of trying to synthesize the issues, considerations and etc. etc. But time has to answer. But it's a beautiful question. Thanks for asking that.
Thank you. Hari.
So, I mean, everywhere, if you really, after the act in place, I tell you, there will be some kind of, sensitization will happen to understand really on the incidents, because every data breach is an incident. And I mean, if you really go to the, I mean, I do audits of many companies. I can't be really taking the names, but I can say by and large, there are many companies who are maintaining very reasonable, very good incident. First of all, incident has to be really recorded, managed. Then it comes response, right? So there are companies, there are enterprises which still need to really reach that stage, but they are trying hard to do that. So going forward with this in place, the incident response or incident, detection and investigation and containing and stakeholders management and all whatever I kind of highlighted in the pyramid is going to be more stringent, so that the data breach response has got so many things, right? And let us really do a small cost analysis of, because if you really look into the cost of implementing the DPDP probably across board, it is some amount, which we have seen in the hypothetical case also. So, but the breaches have got much more penalties. I mean, still, I would really call it out, like, our country is going to implement it and put it in place soon. But imagine in the global arena, it is already in place. But despite that, I don't want to be really naked, take the names of the companies. We all know how much of breach has happened, right? How much of data loss across globally, not India, I'm talking about, right? So, and then they are paying huge sum of penalty, etc. So things happen, but just because things are happening, we don't want to surrender. We want to go to the details and safeguard things. So direct cost, if you really see, there will be some regulatory fine up to 250 crores. There you will have to employ the legal. There will be and notification expenses for informing affected individuals and authorities about the breach and investigation costs. Okay, they're all direct costs. And then indirect costs, loss of customer trust, brand damage, insurance premiums, and that is exactly the place cyber insurance are also coming into place. You might have seen across board, like a lot of insurance, cyber related insurance are in place. Okay, so indirect cost, direct costs these are the direct costs, these are the indirect costs, and you can see that it's up to 250 crores, up to which the breach can really invite fines. Okay, and indirect costs. Now, operation costs. I mean, when these things happen, probably there will be revenue loss to the business because of you put your system down, and that can I've kind of put some hypothetical numbers there. Please don't go with the numbers. For the purpose of illustration, I put that. And you need to really kind of employ security upgrades in line with not only security upgrades. I will even call it that your system upgrade, your software upgrade, your third party management. So many things will be in picture. Okay, and compliance monitoring, lawsuits, settlements. So around 100 crores for a reasonable enterprise it comes to. And so, I mean, it is not, I mean, once the act is in place, yes, these are the things becoming mandated. And if it is not adhered, then probably, say, out of, let us say, probably in a scale of 0 to 10, we are probably in 0 or 1 now without this act. And we may reach 5, 6 quickly. And then reaching that, getting 50, 60 marks in an exam is very easy. 70, tough. 80, very tough. 90, topper. 100, impossible. So, that journey starts now. That's what I'm trying to highlight. So there is a small example, breach cost, because breach cost, once something is breached, a lot of things are in place actually. And so mitigating breach cost, you can do proactive measures, which we have been discussing all along in this presentation. Cyber insurance is another instrument where you can, transfer your breach responsibilities, not breach responsibilities, but cost of breach responsibilities to a third party. And with very strict, sometimes incidents would have happened, you will come to know only later. By that time, so much of damage would have been done. And so that it is important for you to really plan the incident, not only response, but also in incident management. I would like to emphasize with the examples that I have seen in the industries. Main key thing I've seen is incident management. Incident people, tend to think, hey, a computer is down, a system is down, network is down. They are not the incidents. These are all the very specific cyber and data related incidents happen across industries. So got to be very, strengthen that. Maybe with proper tool and reporting mechanism and awareness culture. We talked about culture and awareness some time back. That is also equally important. And data minimization. I mean, if you're going to collect the data going forward, I mean, with all these things in place, I'll tell you, enterprise will tend to really think double before really collecting the data, right? Will that be with the immediate, result of this? Because so far I've been, so it is like, getting into a hall where a buffet is ready for you. I mean, you go and attack any food you want. But when a charge is put in every item and definitely you will think twice, hey, whether I need it or not. I mean, sorry to bring in such an analogy here. We are all human beings by the end of the day. So such a measure is happening now. You really see that. So collect and store only data to reduce potential exposure and liability. And way forward, establishing comprehensive data privacy processes. A lot of frameworks are there. You've got ISO 27701, and you've got other frameworks to really check the controls on, how am I performing in terms of personal data protection. So, I mean, of course, for larger enterprises, I've kind of highlighted the compliance steps here. And risk assessment, baseline establishment, privacy technology, documentation awareness are all going to help, and it is going to be almost mandatory going forward, right? And with that, I'm coming to the conclusion of this particular section, but I just wanted to highlight, the specific use cases that we saw in this, example sometime back here. I've kind of highlighted the very DPDP wordings here so that you can go offline and see what is really given there on their different scenarios. I'm not going to talk about that. They have kind of, the whatever I've highlighted here is from the DPDP Act, but kind of picturesque way I've highlighted here. That is one aspect. And I've also included the exceptions possibilities. And coming to, how it can be. And one important section I would like to highlight is, we discuss about the chapters, right? And the chapter details are given here. And comparing GDPR with DPDP, also I've kind of highlighted here comparison. So which I'm not going to really discuss during this session. I thought post this session for you to go through these, patiently going through these 74 slides may be helpful to you. So I'll share this. With that, let me close this presentation and come back to any. I'll try to answer the questions. The questions are very big, in fact. So I'll try to answer them. Now, maybe we spend a couple of minutes on that before we close this call. Hope the session was reasonably helpful to you in understanding at least an orientation on the DPDP. That is the intention of this session. And I wish all the people have joined. It's okay. Maybe recording can be shared later. So, yeah. Anything that I can answer, please. If I know, I will answer. Otherwise, I'll say I find out and let you know. It's a big topic, honestly speaking.
Maybe if others are fine, I can ask one more question. So what happens is normally, I could look at it. First of all, Hari, this is a very good session. As you rightly say, slides had to literally follow you. You are leading them, and very informative. Thank you very much for your time and doing this walkthrough. Just one question I want to conclude it with my side so that you can proceed. So the question here is, many times the breach is learned from the public. It is learned from the public even before the so-called data fiduciary or the CDPO gets to know, or the company affected gets to know. It is already there in the public. Okay, so how the company is going to, and the DPO is going to manage the 72 hours of information to DP board, from the time of the breach. Otherwise, for the delay in information informing the breach also, there is going to be a penalty. That seems to be very tricky. What is your view?
Yeah. Okay, if I'm right, if my understanding is correct, the breach reporting for GDPR is 72 hours. I'm not sure on the DPDP, the framework has brought out anything yet. That's the reason kind of I've highlighted in one of the later slides like GDPR and the DPDP comparison. But the question, forget about 72 hours or 108 hours or 200 hours. The question is, the crux of the question is, how, without knowing that I have got an incident, I'm going to report it out to the Data Protection Authority is a question. Exactly. That is a question. That is a question. So it's a very big question. I think as I kind of highlighted, if you have really gone, probably carefully watched my wordings, incident management, because when the data is getting breached, there is definitely, because incident management, I will call it out, even in 27K audits I've seen, even some of the enterprises, I won't call everybody, thinking incident management means they're managing their own internal issues. No, it is actually anything they come to know untoward things happening. And maybe you got to really have a robust, policy, standards, and the process and standard operating procedures in place, and promote that across board, within your industry. Thereby, your incident reporting is quick, swift, so that maybe sometimes it cannot be done and manually. It has to be done. For example, I quote on a small example. sometime back Microsoft issue came, right? The patch management, because of that, you all know, some of the airlines got impacted, and I mean, it all came to the surface only after the impact has happened, and I know then the remedial actions took place, and by the time, how much of data, business loss and other things have happened, right? So when I was auditing the systems of some of the enterprises, they also, I mean, if you really see even yourself, out of 100% of Microsoft implementations, only those who have undergone the patch management through that particular CrowdStrike or whatever it may be, I don't remember the name, but have got impacted. There are enterprises who have implemented a different tool for patch management. They said we were safe. Our patch management tool has taken care, not allowing this particular patch into my system. Thereby, I'm not impacted. So tell me where. I mean, see, mistakes can happen, and I mean, it is how much we are really able to safeguard with my tools, and how much we can really protect ourselves matter a lot. So, taking into consideration when you are evaluating your enterprise, especially I will call it out explicitly incident management, because that is where exactly actual problems comes to the surface. That it should be prevented, and if it happened, it should be reported, and it should be managed immediately. So that is very important. So I think Subbu would like to also take this if I'm right. He raised his hand. Subbu, over
Yes,
to you.
sir. Yes, sir. Thank you. Once I say actually what has happened now. So when we say the incident has to be reported within such and such time, though the DPDP has not explicitly specified something, and if you remember, we had been discussing this for a long time, and it has been by default they say the certain reporting, the duration is only 6 hours. In fact, last week or this week, the government of India has stipulated an information security standard for the telecommunication industry in India, wherein they have explicitly specified it is 6 hours reporting to the regulatory body. Okay, now the 6 hours on the certain and 6 hours for the try. Okay, so it's something which is 6 and 6. Okay, when the Data Protection Board of India is going to get formed, for all the practical reason, I would also expect this to be six hours from the time that you are actually discovering the incident. Okay, now given this scenario, for example, if Friday we have gone home, Saturday, Sunday, or Friday after we have gone home, the incident happens. Saturday and Sunday we don't know the incident. Monday morning we get to know the incident. Ideally, from the time we get to know the incident on Monday morning is when we need to report. But the question is when we discuss about the security incident management, the very first phase for the incident management is the preparatory phase. That means you need to have the mechanism to monitor and report the incident 24/7. Okay, now if you don't have it, then it is actually a penalty. For example, Air Europa's case, okay, they have reported the incident after 42 days to the Spanish Supervisory Authority. They have been penalized extra 100,000 euros in addition to 500,000 euros. So they specifically said the 100,000 euros is because of the delay in you notifying the incident and getting to know. They were not even aware that they have been hacked. So 100,000 euros was an additional penalty that was levied on the Air Europa's case. So same thing. See, because DPDP, though people say it is not GDPR and all. See, final roots are from GDPR. If you look at the penalty for 25 million euros, okay, you convert that to the Indian rupee, the penalty that is there for DPDP is almost the same. Okay, though we say the fiduciary, which is not directly mentioned as a controller, all these things are a differentiating factor. But it is like, the body is same, but the shirt is different. Okay, like, I'm wearing a sherwani to match more towards the Indian culture. Other than that, it is almost the same. So when there is actually an incident, privacy incident, you are reporting to Data Protection Board of India, the DPBI will do the investigation. If they find that we have not done anything, we don't have a control to report the incident, to monitor and get to know the incident, report it on time, that itself is a penalty, okay, area for penalty that they can actually charge for the industry. So first step towards the DPDP implementation is to have a very good incident management. Parallelly should also have an privacy incident management process and set up the controls in place. So ignorance is not a bliss in this case. So that's why I'm always saying the privacy incident is actually a security incident. Only thing is privacy has become is a law now. But security is not a law. That's the only difference, sir. Otherwise, it's all the same. So we need to set up the proper incident management. ISO 27035 is the security incident management guideline that we need to implement to ensure that we have a proper reporting structure in place. Over to you, sir. Thanks.
Thanks, Suruji. This is a journey we started. So, things. So, I think we are over short the time. So, let me probably. Subhaji, you want to address before we close the call?
No, sir. I'm fine. I just thought, I just came home. I thought I would love to enjoy your webinar. So maybe the Kavita, do you have the concluding note for this webinar?
Yes, I'll conclude it now. We wanted to express our heartfelt thanks for taking the time to conduct the webinar on the Digital Personal Data Protection Act 2023. Your presentation was outstanding and your expertise greatly enriched our understanding of the subject. Thank you once again for your valuable contribution. Thanks for the attendees as well. We appreciate your attention and engagement throughout this webinar. Please feel free to reach out to us for the further clarification and questions. Thank you.
Thank
This is
you.
all ours, sir. Thanks everybody for joining this webinar. Thank you very much, sir.
Thank you very much. Appreciate it.
Thanks a lot. Bye bye.
Thank you.